Welcome everybody to our live webinar ThinkHouse. I'm David Lowe. I am one of the leaders of ThinkHouse here at Gowling with Michael Luckman. I'm a specialist in commercial contracts and I work heavily with in-house lawyers. Kat, would you like to introduce yourself?
Yeah, thanks David, and good morning everybody, and thanks for joining us via Zoom. As David said, I'm Kat Naylor and I'm a partner in the commercial litigation team in London, and I help clients to navigate their way through corporate commercial disputes, both domestic and across borders.
And that's exactly what today's live webinar is going to be about. It's a litigation survival guide. Now, of course, litigation and disputes are part of any major corporate doing business. Unfortunately, disputes come up and they have to be dealt with. But we thought it was probably a good time to have a little bit of a refresher now here in September 2020, given the disruption that's caused and continues to be caused by COVID and the recession that we're in. It's a classic melting pot moment for litigation. This is when people will feel desperate enough to feel that they have no choice but to litigate and may well make claims, and you may well receive those claims. So today is about a return to basics, but to sort of think a bit about what are the key things to do relating to disputes in their early stages before it's turned into full-on litigation. Kat, do you want to give us a quick summary of what we're going to cover?
Yeah, sure, absolutely. And I should probably start, David, by just saying it's pretty rare that I have a client who actually wants to get into a dispute. But as you say, in the current climate, we're expecting more disputes to happen. So keeping the session really practical, I'm going to cover do's and don'ts for responding to a claim if you're unlucky enough to receive one. Then the other side of the coin, whether to litigate or whether there might be an alternative route, in particular winding up route. A word on terminating contracts in the hope of avoiding litigation. And then on to privilege, what you can do to keep difficult documents out of court without prejudice. What does it mean and when should you use it? And then finally, a word on funding and costs.
So as you can sense, we're going to cover quite a few different topics, but the thing that brings them all together is we think they're the kind of issues that in-house lawyers will be facing as you deal with the run-up to disputes becoming, well, hopefully avoiding them becoming formal litigation, and therefore, the kind of things that are going to be on your desk. Brief bit of housekeeping before we start. Timing wise, we're aiming to come in at about 45 minutes, so we're aiming to end this about 11:15. There is a Q&A function on your browser bar there. If you've got any questions, do pop them in. If they're relevant to the bit we're talking about, we'll pick them up as we go along, or we'll pick them up at the end. If we don't get to your question, then we will try and answer it offline. So if you find that we don't get to your question, don't worry, we'll follow up on that. It is CPD accredited for those of you who are solicitors and equally for barristers. But of course, you need to keep your own records for that to satisfy the SRA. And finally, there is a feedback form. We do appreciate your feedback, particularly as we are all continuing to learn how to do these kind of seminars online. We're obviously keen to hear your feedback and learn from that. So, Kat, let's turn to the first topic. You receive a claim. What do you do?
Okay, well, don't panic. The first point, I think, and it does, I'm being flippant to say don't panic, but actually it's crucial, I think, to have in place the right protocol and training so that if a claim is received into the business, people know what to do with it, and namely bring it to the attention of legal as soon as possible. But it might sound obvious, it's all too easy for somebody to sit on a claim for a few days, to put it on their desk to deal with, and that is a dangerous thing because the time to respond is quite short. I mean, I have had clients who, in a panic, have thrown the claim away because they didn't want their boss to know about it. That is a disastrous thing to do. So it's absolutely vital that you have a protocol in place so people know if a claim comes in, you have to flag it up immediately. And that should extend to reception staff, for instance, or the loading bay, whoever might physically take receipt of a courier coming in and serving a claim personally. So they don't, just chuck the envelope away and put it in a pigeonhole. They need to know to flag it straight away. I think if you're expecting a claim because you've had rounds of correspondence, and it is usual to have pre-action correspondence, so it oughtn't to come out of the blue, but it can do. But even if you're expecting a claim, it can be easy to overlook it if you're on holiday, for example, if it comes in. And I've had a situation happen where a claim has come in, someone's away, it's gone into their in tray, and it's sat there and they weren't aware of it when they got back, so they didn't get to it straight away, and you have 14 days to respond. It eats well into your time. So that's my first top tip: have a protocol and training. It sounds obvious, but it's so easy to get it wrong.
And Kat, you talked about coming in the post or at front desk. Is it possible to receive it on your email?
Well, it is, and people do email, but funnily enough, at the moment, under the civil procedure rules which govern how to litigate, service by email is not a permitted method unless a party's consented to receiving documents that way. Now, you can expressly consent, so you could do that, for instance, in a contract. You might agree to accept service by email, but if you haven't consented, and it can be expressed or implied. So a way of having an implied consent on email is if you filed a court document with an email address on it, you're impliedly going to be accepting service by email. But just out of the blue, claim form by email, that's not proper service unless you've consented to it. The courts haven't quite got up to speed. Fax, first class post, personal service, those are the permitted methods.
Fax? Gosh, you know where your fax machine is.
It's not telex.
So the claim's arrived and it's found its way onto your desk. Now what?
Well, I mean, there's a whole host of substantive points to consider. I mean, you're going to want to get to the bottom of the merits of the claim straight away. And that's really obviously vitally important. But in terms of practicalities and procedural elements to focus on, there are some quite obvious points that you should think about early on, because actually, if a claimant's got certain procedural points wrong, and service is a good example, then it could be a bar to what is otherwise quite a good claim. So when you get a claim, I'd have a checklist, and my checklist, I think, first of all, are you insured for the claim? So think about whether there might be some insurance that would meet the costs of dealing with it. And the reason that you think about that very early on is most insurance policies require you to notify straight away. So check whether you're insured, and if you are, notify your insurers. Next point on the checklist, it's really important to keep a note of how the claim has been served for the reasons we've just talked about. Service is prescribed and you've got to get it right. But it's, when was it served? How was it served? What else was served with it? So to give an example of how it can go wrong, I've had a situation quite recently where the claimant served by post, first class post, absolutely fine, but unfortunately didn't put the right postage on the envelope. So the claim came to our client's attention, but they had to pay the, 40 pence short postage, and that was not good service. And so that claim form lapsed. The claimant had to reissue the claim form 4 months later and pay another £10,000 to do so. So not fatal in that case for them, although an expensive mistake. But if you have a limitation issue, then if the other side hasn't served properly, you might find yourself with a complete defence. So service, keep a record, keep a note of the envelope it came in. As I say, that's really important. Have a think about jurisdiction. Is the English court, and we're assuming we're talking about English court for this talk today, but is the English court the right place? So is there an arbitration agreement? Actually, they should be arbitrating, not litigating. Have you agreed that some of the forum abroad would be the right place? Similarly, law, check that it's English law, actually. It may be that you've agreed a different law should apply. And then I think I've already made this point, but absolutely vital on your checklist, act quickly. You've got 14 days to respond. Don't hang about.
And so, Kat, if you that person who threw it in the bin because they wanted to hide it in totally denial, if that happens and you don't respond to it, what happens then?
Well, if you don't respond within the requisite time period, and as I say, it's in most claims it's 14 days of service, unless you agree an extension, which is something most people do. then the other side can automatically get a default judgment. And that is as simple as filling in a form, sending it to the court, and the court will enter judgment on the claim in the full amount of the claim. Now, it is possible to have that default judgment overturned because it's entered in your absence, and there's a whole procedure that you can follow to do that. But you have to have good reason, and it effectively means you're starting from the back foot. You know, you're having to make this defensive application. The costs will be for your account, so you'll have to pay all of your costs for making an application. You'll also have to pay the other side's costs for dealing with it. So default judgment, bad thing. I mean, also, I mean, once you have it overturned, fine if you can, but a default judgment is still a judgment, so it'll be entered on the judgment register, and that can affect credit rating and all sorts of things. So you really don't want a default judgment, and certainly not as a start of a 10 in litigation.
Kat, there's a question just popped up, and I'm going to pick it up now because it's relevant. Somebody's asked, would any allowance be made for working from home? You know, because the post goes into the office, and then it might take a little while to actually get to you at home. Is that relevant?
Well, it's a good point. It might be a good reason if proceedings had been properly served, but they weren't brought to the attention of the right person and default judgment was entered. That might be one of the good reasons that you'd be able to pray in aid for your overturning application. But you would, as I say, you would normally expect that there be some pre-action correspondence. And so if you are anticipating a claim, one of the things that in the current climate it would be sensible to do is to agree with the other side how you are going to accept service and where they should serve the documents. And I know that may sound like you're giving them an easy ride, you're not allowing them the opportunity to get it wrong, for example, but the consequences of them getting it right and you not noticing it, I think, are probably greater. So I think some element of cooperation is probably needed at the moment.
And I guess the other thought is actually sensible office management it should be that you shouldn't be letting the post pile up in the office. Somebody right. needs to go in and open it and deal with it and scan it in and circulate it reasonably promptly, so you don't get in this situation. Well,
and that goes to my first point, which is to have, make sure that those people on the front line know what they're supposed to do if a claim comes in, that it doesn't languish in a pigeonhole or in an in tray somewhere and get overlooked.
Yeah. And gosh, we're getting more questions here. Another one which I think is really interesting is somebody's asked, we get a number of claims served on our stores and not the registered office, which then results in delays and claims not being forwarded onto the right department. If somebody sends a claim to a store and not the registered office, is that good service?
So potentially it is. I mean, it's a place. It doesn't have to be the registered office. It's a place of business. So I think I suppose it really does depend on which store and how many stores you have. But I think there is an argument that would be good service. And it goes to what I wouldn't want to do, I think, in those circumstances is just ignore it and assume that it wasn't. And I think when you have a lot of stores, a lot of regional offices, for instance, again, it's the training point just to make sure that everybody who is on the front line knows if they get served with something that they bring it to the attention of whoever it is absolutely as soon as possible.
Yeah, so standing orders to the store manager is, if you get a claim, send it to the head office immediately.
Yeah, and straight away. Let people know. Don't sort of just put it to one side and deal with it later. Deal with it straight away.
Great. All right, I've distracted us with those questions, Kat. So we're back with. So we've talked about your checklist of things to do when you received a claim, the need to act quickly, default judgment. Anything else that's sort of happening in that sort of golden moment on receipt of the claim?
I think there's there's a whole load of other things, but I think there's probably two other key points. I think, in no particular order, I think have a think about whether there is scope for avoiding litigating. And I appreciate once you've had a claim, you're already off to the races, but think about whether there's scope for mediation or negotiation. Can you pick up the phone to the other side and say, look, this has gone too far. Is there a way to resolve this without spending the time and cost of litigating? Because as I said, most people actually want to avoid litigating, because it is a distraction from core running your business. So it is galling at the get-go to think about paying anything for a claim that you don't think is meritorious. It's also galling if you're on the other side of the fence, accepting a discount on a claim that you think is a good claim. But actually, if you do the cost-benefit analysis and you put your commercial head on, is it worth spending the time and cost of fighting? Or could you possibly pay something, take a discount now to draw a line under things very early on? And if that's possible, that's certainly something to think about. And then I think the final point is evidence. So if you can't settle the claim and there is nothing fundamental in the procedure that would invalidate it or would appear to invalidate it, you need to think about securing evidence. And I don't mean running around at the very beginning and taking witness statements and all the rest of it, but you need to, for instance, preserve documents. So if you've got an automatic email deletion policy, for instance, you need to get onto IT and say, stop, we don't want to destroy anything else. Because if you get to the point of disclosure down the tracks and you have destroyed documents completely inadvertently and as a matter of course, even in those circumstances, the court could draw adverse inferences. Once you get notice of the claim, just draw a line under any sort of deletion policies.
Great. Okay, so that's talking about receiving claim. Flicking around to you've got a dispute, somebody owes you some money or whatever, and you're trying to recover it and they're not responding. I mean, one way you can go is, do set off formal litigation, but is there any other alternatives you should be thinking about?
Yeah, for sure. I mean, I think if we, obviously there's a whole array of alternative dispute resolution mechanisms available to you. So talk briefly about mediation, but there's negotiation. But if you've tried, let's just assume in this hypothetical world, you've tried to negotiate and you've got nowhere. Litigation is obviously one route, so court proceedings. An alternative, if you have a debt claim, and in the current climate, we expect that those will increase because people are just trying to avoid paying the bills. There's an alternative, which is a winding up route, which could be much quicker and cheaper than litigating over a debt. Now, the courts actually don't like commercial parties threatening to wind each other up for unpaid debts. But actually, it can be a very effective way of getting paid. It has to be a debt, so it has to be a definite sum, and it has to be a debt which is undisputed. So it has to be, as I say, an invoice which, for whatever reason, just isn't getting paid. And if you have a debt and it's an undisputed debt, then you can serve what's called a statutory demand, and statute is the Insolvency Act. But what that is, it's a one-page document, two-page document. You set out in very brief details the nature of the debt, serve it on the other side, and what that means is within 21 days of service, if they haven't paid the debt, you're entitled to seek to wind the company up for its failure to pay. Threat of doing that, funnily enough, can immediately unlock payment, and it is, as I say, for a solvent company, a very effective tool because it's very, very cheap to do. The threat's severe, and the reason the threat's severe is because nobody wants to be wound up, but even just presenting a petition, that has to be advertised, and so it will come to the attention of the public. It will affect your credit rating, it will potentially affect your banking facilities because of winding up petitions been presented. So, as I say, solvent corporates tend to pay very quickly on receipt of a statutory demand which is properly made. Obviously, if the statutory demand doesn't have the desired effect, you have to decide whether you're going to go through with presenting a winding up petition. If you do that, again, it is quicker and cheaper for an undisputed debt than litigation would be. But if the company is insolvent, in fact, you then take your chances with the other creditors of getting paid. And I think just a note of caution on the winding up route. As I said, it has to be a debt, it has to be undisputed. If you threaten to wind up a company in respect of a disputed debt, you might find yourself on the receiving end of an injunction preventing you from presenting a winding up petition. And if the court considers that it was an improper thing for you to have done, an abuse of the court's process because the debt's disputed, then you might find yourself on the receiving end of a costs order. So it's not something to do lightly, but it is certainly, as I say, for an undisputed debt, a really effective tool.
It sounds like if you've got a large invoice and you've been given the runaround, and the other side is just refusing to talk to you, or it's not my department, that kind of stuff, then that might be a good situation. There's nobody's disputed the debt, but it's a good way of getting somebody's attention.
Yeah, oh, absolutely, and it does.
And somebody just asked, are there any implications on the party serving the stat deck for winding up, e.g. unjustified threat? I think what you were saying is your risk of cost order if it actually was disputed.
Yeah, if you serve a statutory demand when you don't really have a proper basis to do so, you could still get paid. But if the other side is properly advised, they would write to you and say, this is improper. Will you please give us an undertaking that you won't present a winding up petition? And if you refuse to give that undertaking, then they are likely to go to court and get an injunction to stop you from doing it. And if they can persuade the court that it was wrong, the cost of that will be for your account. So it might be worth having a try, but under the risk that you may end up on the wrong side of cost. But if that's big enough, it could be worth a go.
Yeah.
I should probably make a point, actually, that question reminded me about service. I'll make a very quick point about service. You will, if you do end up having to present a winding up petition, you'll need to explain how you know that you served the stat demand and it came to the attention of the right party. You can just post it to the registered office, leave it at the registered office. What I would normally suggest doing is using the process server. They will go and physically hand it over to somebody, and then they will do a really short witness statement of service saying, I handed it to Joe Bloggs at 10 o'clock at this address, and that will then be evidence of service having been properly affected. And you're talking about a couple of £100. It's not an expensive thing to do.
Yeah. Great. Okay. So we talked about receiving claims. We talked about making claims, and particular thinking about using a statutory demand as an alternative way. I guess, though, for many in-house lawyers watching this, they'll probably say, well, the beginning of the dispute usually is I get asked, how can I get out of this contract? How can I terminate it? And I don't know, my experience recently is, I've spent a long time helping clients enter in long-term agreements, and then 6 months later they wanted to get out of it, and I sigh, and I then start turning pages to the termination clause. And obviously it's a big topic, but have you got any thoughts on that?
Yeah, absolutely, and it is a big topic. You're absolutely right, but keeping things really practical, as we're trying to do today. As you say, David, get the contract out. What does it say about termination? I know that sounds obvious, but that's the starting point. So, is there a termination for convenience clause? If there is, what do you have to do? Do you have to serve notice? How long is the notice? What are the transition arrangements? But if there is no termination for convenience clause, and often there isn't, for obvious reasons, people want certainty of the contract, then is there a breach that might entitle you to terminate? And again, that very much depends on what has happened in fact. But has there been a breach? Are you entitled to terminate for the breach? Has there been, and the current climate, excuse me, is relevant here, has there been a force majeure event that would allow you trigger a right to terminate? Not all force majeure clauses give rise to a right to terminate, but many do. If you do have a right to terminate, excuse me, it's really important that you comply with what the contract says about it. So if you are required to give notice in a certain way, you have to give notice in a certain way. Failure to do that may well affect your ability to terminate. You won't be properly terminated if you haven't given notice properly. Now, if you don't have a termination clause in your contract, then you might be able to imply a provision for termination. So, the courts are, when you've got two commercial parties who've negotiated a complicated contract, the courts are pretty reluctant to start implying terms, because the basis is, you should have asked for what you want. But it is possible to do if you have a contract without end. But then you get into what's a reasonable notice period and all the circumstances, and that's really a question of fact. And again, one where there is scope for a lot of disagreement, I can imagine. Alternatively, if you don't imply a term and there's been a breach, then you may be able to rely on common law repudiatory breach to bring the contract to an end. Everybody hopefully on the call will appreciate repudiatory breach has to be very serious, has to go to the heart of the contract. So it is quite a finely balanced question of weighing up what has happened in all of the circumstances. But if there's been such a serious breach to justify termination, then you can rely on that breach and terminate. You have to, what I should probably also add, it's not an automatic, repudiatory breach doesn't automatically bring the contract to an end. You have to decide whether you're going to accept the repudiatory breach. But if there's been one, you do want to accept it, you then just give notice to the other side saying you're in repudiatory breach and we're happy to accept it, contract's ended. Made it sound very simple. It's an area where, as you say, we're asked to advise all the time because it's really very difficult.
Let's imagine it's a contract where there's no termination for convenience, and you're alleging breach because there's a clause that says you can terminate a material breach. I can imagine though that the other side's going to debate whether there is a material breach. I mean, if you get it wrong, what's the consequence?
Well, if you get it wrong, and material repudiation, I think probably you're in the same boat. If you purport to terminate a contract for the other side of material breach or repudiatory breach, and you've made the wrong call, I mean, that would be a matter for the court to decide down the tracks. But the consequences are potentially quite severe because you flip the position, you would then be in material breach of the contract yourself because you have alleged you've purported to terminate when you have no right to do so. So you would then be the contract breaker, and you would be the one who would be required to compensate the other side for the loss of the contract. So suddenly you would be paying damages to them when in fact you thought they ought to be paying damages to you. So it is quite a high stakes call. Yeah,
and so I mean, if it's obvious and it's a massive breach, easy enough. But my experience is most breaches aren't as obvious as that, and you're in that grey area worrying.
Yeah.
And certainly, the lesson from as a person who drafts and negotiates contracts rather than somebody like you who destroys them, Kat.
Defends them, David.
Of course, defends them. That's better. But I sort of, my experience is a termination for convenience right is just so valuable, and it's worth having even if it comes at a cost. You know, a break clause that says you can terminate after 3 years on 6 months' notice, but you have to pay £500,000 for the right to do so. When somebody says, "Can you terminate it?" if you can point to that clause, then it makes it all much clearer and easier, and can help concentrate minds.
Yeah, I mean, another potential tip is in respect of time of the essence. So if there are certain obligations that you think ahead of time you might be able to rely on the other side's failure to do something in a timely manner, if you make that obligation of the essence, then that would give you a right to terminate for repudiatory breach if they don't comply.
Yeah, that's a good thought. That reminds us all in drafting contracts why, if you're the person under the obligation, why you want to avoid it being times of essence, because it can then be used against you some other time and giving you that right to terminate. The other one, Kat, I see is there is a right to terminate for convenience, but it's it can only be exercised in a sort of 5-day period, once in a blue moon, and only if it's on a millennium, and it's all kinds of, and that they, in my experience, most people miss those, and they'll then try and the day after that envelope to terminate, and of course they can't.
Yeah, strictly construed, absolutely. That's the right. You missed your window, you lose the right.
Yeah. So a sort of the ideal thing in a contract at the time you want to get out is a nice rolling right of termination on convenience on short notice. That's the ideal when you're at that point, isn't it?
Yeah, I suppose so. I suppose so. Although I'd be interested to know if anybody would actually agree to that. Anyway. That's your job, not mine.
I've got a client who does enter in quite long-term contracts, but in their standard terms, and okay, they don't always get their standard terms, but in their standard terms, they have got a rolling right to terminate at any time on 3 months' notice. So where the other party has, either because they're in a poor negotiating position or because they haven't read the terms, have just signed up to them, it obviously locks in a good position. If the contract is struggling for some reason, there's an easy exit for them.
Yeah.
Anyway, that's enough
Well
of
done.
the so we talked about making claims, receiving claims. We just talked about terminating contracts. Now, just stuff that comes up in this world that, if you're not a litigator, you sometimes wonder what it just means. So the first one that occurs, and you mentioned at the beginning, was privilege. I find it really confusing. What is privilege, and what's the point of it? How does it help?
Well, it's another topic in its own right, and I will try and avoid getting bogged down in the legalese, because we're trying to keep things practical. But in essence, what it is a shield to protect you from having to hand over difficult documents if you get into a litigation. So, taking a step back, the English courts at least require a cards on the table approach in litigation, and what that means in practice is that you will get to a point in litigation where you have to give disclosure of documents, and that is a very onerous obligation. You have to give disclosure of all relevant documents to the disputes, issues in dispute, even if they are difficult documents for you and they support the other side's case, and even if they're commercially sensitive. So all of those have to go over to the other side, unless you can rely on privilege to protect them from being sent across to your opponent. It's another area, I think, where training is key. And it sounds obvious again, but it's all too often in practice that people create really difficult documents. So the first thing I think to think about privilege is just don't write anything down that you wouldn't want the court, wouldn't want to be read out in open court, because people do. I've had an example of in a piece of litigation where somebody in the business periodically wrote stroppy memos about all of these terrible things that were happening, and sent the memos off to somebody else in the business, beautifully presented. I don't know how they were received. Presumably there was sort of an eye rolling and they went into a drawer. But unfortunately, some years later, some of those issues in the memo were the subject of litigation. And so all of those memos were disclosable, and all of them going across the other side. Oh, you knew about all of these issues, X numbers of years ago. Terrible, terrible situation for that client. So ideally, don't write stuff down. Now, privilege, privilege would not shield that sort of document. It has to be some kind of legal advice. Effectively, it was legal advice to litigation privilege. And just really, really quickly to recap on both of those, legal advice privilege is it will serve to protect legal advice, so you don't have to hand over your warts and all counsel to counsel discussions. So it has to be confidential communication, lawyer and a client, for the dominant purpose of giving or receiving legal advice. So very, very easy if you've got external legal advisors. Much more of a grey area where you are an in-house counsel giving advice to your internal client, because where it's legal advice, yes, that would easily be covered. But more and more, I think in-house lawyers are being asked to give commercial advice alongside legal advice, business advice. There might be an administrative function as part of legal, and I think then you have got grey areas. So practical tip there: if you are giving legal advice and commercial advice in respect of an issue, separate the documents out. So your legal advice will obviously be privileged, commercial advice won't be. And I think labels, again, they're not determinative. You can't just slap the word privilege at the top of a document and then you'll never have to give it to the other side. But if you are creating a document which you know is going to be privileged, then you put privilege on the top. It's a red flag. If you get into a disclosure exercise, it will at least give the people who are reviewing the documents pause for thought. Just again, very quickly on legal advice privilege. One of the absolute prerequisites, as I said, is it's got to be confidential communication. So if you are, if you lose the confidence in the document, then even if it's legal advice and even if it's between a lawyer and a client, then you've potentially lost the privilege in it. So what that means in practice is just don't, if you have privileged documents, don't disseminate them far and wide. It is possible to share them within the business on terms of confidentiality for people who need to know, so board members, for instance, key members of the commercial team, but just keep that circle as small as it needs to be and no wider, because the greater the circulation, the bigger the risk that you've lost the confidence in the documents, and then they won't be privileged, and then you'll have to hand them over, whatever they say. Litigation privilege is perhaps a bit easier. It's confidential communications again, so confidence is still important. But it's lawyer and client, or either of them and the third party, so it's wider. So that would extend, for example, to communications with accountants, which wouldn't be covered by legal advice privilege. But those documents, those communications are for the dominant purpose of litigation, which is contemplated or pending. So if you're into a litigation, all of your communications about it ought to be protected by privilege. So again, if you're talking about a claim internally, provided that isn't with the entire business, such that you lose the confidence, those communications should all be protected. So litigation's a bit easier once you're into it.
Great. So pre-litigation, start with the assumption that you're going to have to hand the documents over and therefore try to avoid creating things that are going to be embarrassing. But there is potential privilege for the legal advice. As an in-house lawyer, bear in mind you might have to do your legal advice and your commercial advice separately. But then once you've got litigation, well, it all gets a little bit easier, but it will obviously be sensible to, at that time, to take some advice to understand what the scope of that privilege is, to make sure you're not inadvertently causing a problem. Does that be?
Yeah, I think so. And a word of caution, in litigation, as I said, most things are covered if they're communications made for the dominant purpose of the litigation. But settlement discussions are a trickier area because they constrain to commercial, the purpose is commercial rather than legal. So there is some, and I think it's pretty unfair actually, but there is some case law which suggests in some circumstances discussions around settlement and numbers and how much we should offer, they're not going to be protected by litigation privilege because they're not for the dominant purpose of the litigation. There's some other commercial purpose. I know, but it's out there. So just a note of caution, don't get on the WhatsApp group, to talk horse trading. Try and couch it in the bigger picture, the strategy of litigation, and I think you'll be covered.
Okay. So that's probably quite timely to move us on from privilege to, as you mentioned, settlements to without prejudice. And okay, I see people, as soon as they start getting into any kind of difficult conversation, seem to start slapping without prejudice on all their emails. What does that mean?
So without prejudice, it's another rule which operates to keep, I suppose, difficult documents out of court. So what it does, it prevents genuine attempts to settle a dispute from being put before the court as evidence of an admission. So to use an example, if you're in a dispute, you think that you are on the right side of the dispute, and that if you went all the way to litigation, you would win. But you don't want to incur the time and cost of doing that. So you want to make a commercial offer to settle. You're very happy to, take 80% of the claim, for instance. You make that offer, you make it without prejudice. That means that if the other side rejects it, the fact that you were prepared to make that concession doesn't go in front of the judge when he or she is considering who is liable in that case. So you can freely make genuine attempts to settle without fear that will come back to bite you down the tracks. So, I mean, we often see without prejudice stuck at the top of a letter. That will not make something which isn't without prejudice in the same way that writing privilege won't make a non-privileged document privileged. But it's useful to use labels. So if you're making an offer, put without prejudice at the top of it, because that will then flag to the other side that you are making a settlement offer, a genuine attempt to settle, and they won't be able to deploy it in court. I think the other thing, I mean, you know, I'm referring to documents, but it may be that you have a without prejudice discussion. You might pick up the phone, or you might have a meeting or a mediation, for instance. Again, if you want to have a free and frank exchange of settlement offers, then couch those communications in without prejudice, and you'll be able to have that free dialogue.
And you sometimes also say without prejudice, save as to costs. What does that mean?
It's quite a mouthful, but what it means is you can't refer to those communications on the question of liability. So again, you can't show them to the court at that stage, but you can show them to the court at the point where liability has been determined and you are arguing about the costs. So, and the reason you might want to do that is if you've made a really generous offer to the other side and the other side have rejected it, and then you've gone on to trial notwithstanding your offer and they have failed to better it, you might want to show, when the usual cost rule in English litigation is that the loser pays the winner's costs. Well, if the winner hasn't done as well as they would have done some months ago, and you've all spent lots of costs getting to that point, then you might want to say to the court, well, hang on a minute, we tried to settle this months ago, we've all spent loads more money since, please can you make a cost order which reflects that? So without prejudice, saves to costs means that you can, on the question of cost, you can then show it to the court.
One of the questions, it's been answered, so thank you to that person.
Good.
Good. Costs, that's probably quite a good for our final topic, because obviously when you think litigation, you think of costs, and it can be expensive, can't it, litigation? But I'm conscious that, I'm showing my age now, but when I was a trainee, litigation just cost lots of money and that was the end of story. But now I hear there's of all kinds of conditional fee agreements, litigation funding, insurance, all that. I'm now totally confused. Quick summary of what the litigation funding options are?
Yeah, sure. And as you say, these days there are lots of products out there to help fund litigation, or to share or manage the risk of litigation. The most innovative is litigation funding, I think, and it's the newest. But there are some big players in the market. So in essence, a third party, it's their business, a third party will agree to fund a case in exchange for a share of the upside. So, I mean, it's only suitable for claimants or defendants who have a counterclaim, because you have to be entitled to some damages down the tracks. But what they will do is they will fund the proceedings, and they will then take from the winnings their cut, if you like. Now, the ratio in the market at the moment is about 3 or 4 times investment. So if they have funded a case, say £1 million of fees right through to trial, they funded the £1 million, they would like 3 or 4 million at the end of it. So obviously it is really, I mean, there are some funders out there who will fund smaller claims, but it's only really a goer if you have a big claim. But if you do have a big claim, but you don't want to pay to litigate it £1 million, it's a very, very useful thing to have. It really protects your cash flow. And the other thing it does, it's a bit of a check and a balance, because a funder, before they invest that sort of money or agree to invest that sort of money, they are going to want to know the ins and outs of the claim in a lot of detail. They will scrutinise, they want QC's opinion, for example. So it's actually quite a helpful second view on the merits of your claim. If you think you've got a good claim, your legal team thinks you've got a good claim, somebody completely fresh to it coming in scrutinises it and says you've got a good claim, you can feel a lot more comfortable in pushing the button. Now, third-party funding, as I say, it's not suitable for all cases, and there are cheaper ways of funding your own costs than giving up 3 or 4 times investment, and that's conditional fee agreements, damages-based agreements, which are both agreements that you might agree with your external legal advisors. And they're a sort of risk-sharing approach. So CFA, conditional fee agreement, traditionally it's what you'd call a no-win, no-fee arrangement. And actually in practice, those are more usually a lower fee. And then if you succeed, the remainder of the fee will be paid plus a success fee, plus an uplift. So it is, you pay as you go, but you pay less as you go, and then a little bit more if you win. And those are more common than damages-based agreements. With a DBA, it's contingency fee. It's like the US model. So there is an agreement which means that the lawyers don't take any money until the end, and then they take a chunk of the winnings. And the cap on that in England is 50% of the recovery. So you can see again, the £10 million claim, the lawyers will work for free, but then they'll potentially take 5 million at the end. Unlike with the CFA, there's no hybrid option, so you can't sort of agree to fund half of it and then only take a smaller chunk. And so in practice, they're pretty rare, actually. I think the other side of the coin, so other side's costs, insurance. So you can purchase after the event insurance, and that will insure you against the risk that you might have to pay the other side's costs at the end of the day. It used to be that all you could get was an upfront premium, and that would cover you really, really expensive, prohibitively so in some cases, and particularly now, you can't recover from the other side the cost of the premium except for really, really, really limited circumstances. You used to be able to do that, but now you can't. So the market's evolved, and now you can get, you could do staged premiums, for example. So you're paying a little bit in case the case settles, for instance. You're not paying it all up front, you're paying a little bit as you go, or you can even get fully contingent premiums that are only payable right at the very end. Of course, there's a cost to that, so the more flexibility, the greater the cost. But again, it's just one of the products that's out there to help kind of manage the risk and fund claims which otherwise you might not be minded to bring.
So for those listening to this, I guess if they've got a potential piece of litigation where it's a good claim, but the business is put off making the claim because of the costs, the cash flow, the cost risks, paying the other side's costs, actually it will be worth the conversation with somebody like you, Kat, to see if there are any creative options. If it's good enough a claim, it might be able to go down one of those other funding routes and achieve it, bearing in mind cost is not the only risk of litigation. It also drains huge energy, so I wouldn't encourage people to litigate unnecessarily, but there are options, I think, is what you're saying.
Yeah, absolutely. And it's one of the things to think about early on, actually. Just, is this a claim that might be suitable for some kind of external funding? And it's generally if it's a big claim and you wouldn't otherwise be wanting to take the risk of it. So funding is a really helpful tool out there to bring good claims, which perhaps have too much risk attached to them.
Yeah. I see there's a question here. I don't know if this is one you'll be able to answer, Kat, or whether we might need to do it offline. But the question is, are third-party funders able themselves to buy insurance to protect their position in the event that the defendant wins at trial?
Yeah, so you would often find after the event insurance being combined with any one of those other products I spoke about, because that protects the risk of the other side's having to pay the other side's costs. I mean, the difficulty with after the event insurance policy is the premium, and they can be very expensive. But the premium will also depend on the merits. So like a funder, the insurer will want to do their own due diligence, and they will want to know what the prospects are. So if you have an ATE policy and a funder, so you've got the insurer and the funder both looking at claim, then you have three sets of eyes on it. So you want, I mean, there's no such thing as a slam dunk, but you would hope that you're on the right side if you've managed to get it through the kind of risk committee of all of those people.
Yeah, that's great. I'm conscious we're getting close to the end of, well, we're past the end of our time. There's a few questions here that I didn't manage to pick up as we went through, so if I just pick some up. One of them's on without prejudice. Somebody said, am I better just to put without prejudice save us to costs on everything rather than without prejudice? Because so that you can then use it later. Any view on that?
I would. I think if you think that it's likely to litigate, or if you're in litigation already, then I would usually use without prejudice save us to costs, actually, because you don't lose anything down the tracks, and it's quite a helpful threat, I think, because it's both a shield to protect those communications being placed before the court, but it's also then, in that case, a bit of a sword to say, if you don't play ball and you don't be sensible here, we could potentially come after you for some costs.
Yeah.
It's used a bit less now because we have, and I don't get into a whole different topic, but we have, under the civil procedurals, we've got Part 36, which prescribes the cost consequences of making formal Part 36 offers. So you don't see without prejudice saves to costs as often as you used to do. But if you're having a commercial negotiation or a discussion, then yeah, without prejudice saves to costs is still, it's very useful.
Good. Just there's two more questions, and I think we're done. One's about the privilege point. Somebody said legal advice and commercial advice is very often closely linked. And Kat, you talked about, so you might set your legal advice and your commercial advice separately. The question is, do you need to send it as two separate emails, or could it be a single email with the legal advice and an attached document, or very clearly headed commercial advice or legal advice? Can I just, because I guess the person asking the question is thinking about how to make it digestible to the commercial internal guy reading it.
I think, absolute gold standard, keep them completely separate, but I mean, reality check, that might be quite difficult in lots of instances, in which case next best, keep them separate in separate subheadings, separate sections, attach the privilege document behind, make it very, again, use labels, make it very clear that bit is privileged. What you would end up then, if you were having to disclose those documents down the track, because you'd have to disclose, because the commercial bit is relevant, you'd end up with a redaction potentially, or you'd end up being able to withhold the attachment, but you disclose the covering email. It is permissible to redact for privilege. If you get into a disclosure exercise, that's absolutely fine. What it does, though, is it draws massive attention to the document, and everybody is suddenly fascinated by it. And so you can then get into specific disclosure applications, and in an extreme situation, somebody will look at the document, the bit of the redacted document, to decide whether you were right to redact it or not. So it's a bit of a red flag to a bull, a redaction, but it's absolutely permissible and it happens all the time. So just being sort of realistic and practical. If you have to mix the two, try and segregate them within the document, within the email, with headings, subheadings, or as the question suggested, as a sort of appendix or an attachment.
Great. Last question on notices to terminate. Somebody's asked, is there a format for serving notice to terminate, or will a simple letter do?
Simple letter ought to be fine, unless there is some particular prescribed form in the contract. So if you're exercising a contractual right to terminate, do what it says in the contract. If you are exercising a common law right to terminate, i.e. repudiatory breach, then a letter is absolutely fine. You just have to be really clear about, in the letter or in the email even, what is, on what basis are you purporting to terminate, and the fact they can then be left in no doubt of your intentions. But yeah, letter is absolutely fine. Yeah,
and my experience, most contracts they don't typically prescribe a format. It's just notice in writing is what normal. But you just have to watch out. There's the odd contract out there that has something a bit more specific, doesn't it?
Yeah, well, the notice in writing, I mean, that's, again, there's a heap of case law on whether writing would include an email. I think if the contract provides for notice in writing, you should probably do it in a letter.
Yeah.
Just to be absolutely safe. Let's avoid the debate and just cut through it and send a letter.
Yeah, you don't want to be a test case, do you?
Well, I mean, it's just try and leave the sort of satellite litigation issues off the table and notice in writing by first class post. Do a letter, send it in by first class post, put the right postage on it. You've done everything that you need to do. Yeah,
I mean, yeah, there is now a trickle of cases about is an email and writing, what is a signature in an email, and the courts, from what I'm seeing, are being pretty pragmatic and sensible. But as you say, why be one of those disputes just because you insist on sending an email? Why not just stick it in a letter and send it? And send a copy by email if you want, to just make sure you're not going to be a test case.
Yeah.
Kat, thank you very much. That's been really useful. We've covered a lot of ground there, from litigation funding to statutory demands, from privilege to making claims. So thank you for managing to sort of get that down into 45 minutes plus 10 minutes on questions. So really good. And thank you to our audience, and particularly for your questions. We've had lots of questions there, which has really made this an interactive session, even though I can't see you all, unlike a normal ThinkHouse. I'm certainly missing seeing you all, and I'm hoping that our next ThinkHouse in the spring will at least have some physical element to it.
I'm glad somebody was there, David. It was, it wasn't just us two talking, so it's good. It's good to know that actually somebody was listening. So thank you very much.
If you've got any further questions, do let us know. We can deal with those offline, and of course, do fill in the feedback. That would be really appreciated. This live webinar is live, but it's also been recorded. So if you've got colleagues who want to watch it, they will also be able to see it. And if I remember rightly, we'll be sending you a link to this after this, so you'll be able to forward and share it if you think it's useful. Thank you very much.